Good afternoon and welcome to the Appellate Division First Department's virtual oral arguments. I will begin by the call of the calendar and giving the allotment of time. Counsel, please remember the time is for you, not for the court. If we have more questions, we can continue. People versus Carlos Diaz. Counsel for appellants, you have 5 and 1. Counsel for respondents, you've been allotted 5. Del Valle versus 1733 Unico. Counsel for appellant, you've been granted 4 and 1. Counsel for respondent, you've been granted 4. W. Jasmine versus Malcolm H. is submitted. Pearl Binder Holdings versus Patel is submitted. Sen versus GR Realty Holdings, appellant, you are granted 4 and 1. Respondent, Union Square, you're granted 3. Plaintiff respondent, you're granted 3. People versus Johnny de los Santos Martin, are any counsel present? Hearing none, that case is submitted. Alvarez versus XL Specialty. Counsel for appellant 6 and 2. Counsel for respondent 6. Thomas versus Weitzman. Appellant 5 and 1. No, I'm sorry, that case has been submitted, has been adjourned. My apologies. People versus Tiana Perez. Is counsel present on that case? Hearing no response now or at the earlier call, that case is submitted. People versus Carlos Ramos. Parties have indicated they will submit. Protostorm Inc. versus Foley and Lardner. Appellants, you have 5 and 1. Respondent, you have 5. American Transit versus Acosta. Is appellant counsel present? Hearing no response, that case is submitted. People versus Floyd Thorne. Appellants 6 and 2, respondents 6. People versus Joel Sanders. I understand there is a pro hac vici application. Counsel, I will hear you on that application.
Thank you, Your Honor. This is Jessica Masella of DLA Piper, a New York attorney, moving for the admission of my partner, also of DLA Piper, Christopher Operson, to represent the appellant on this appeal.
Thank you. That application is granted. Counsel, you've been granted 8 and 2, and respondents, you've been granted 8 minutes. Iacovacci versus Brevet Holdings, 2 matters, both are submitted. First case on the calendar, People versus Carlos Diaz.
Good afternoon.
Go ahead, I'm sorry.
Okay, sorry. Good afternoon, Your Honors. Svetlana Kornfein for appellant Carlos Diaz. The evidence that Mr. Diaz intended to kill the complainants by setting fire to them is legally insufficient, and the verdicts of attempted murder are against the weight of the evidence. In this case, there's direct evidence of Mr. Diaz's intent. Immediately after the second incident, he went to the police station and made 3 statements. In the first 2 statements, he talked about his plan, and in the third statement, which was an interview with the prosecutor who asked him for details of the plan, Mr. Diaz said, and I'm going to quote him, that he wanted to hurt them so they would suffer by burning them, not killing them, but burning them so that they would suffer like I'm suffering and leave it all like that. That's what I was thinking. Since direct evidence is recognized as the most reliable evidence, it obviates the need to determine intent through inference.
Is that the end of the counsel? Is that the end of the inquiry that the defendant says that wasn't his intent?
Well, there's no reason to discredit him. Mr. Diaz,
should we not evaluate whether his actions had the potential to cause death? And why would we not infer in this instance that that certainly could have been the case?
It certainly could have been the case, but the mens rea
Sounds
element.
like it's Judge Friedman. It sounds like
Yes.
it's a little bit more than could have been the case. I mean, when you put someone on fire and when you sprinkle gasoline and then seek to ignite that, you're not in control of whether it's just going to be a little fire or a big fire or how much damage is going to be done. The natural outcome of something like that is that you very well may murder someone.
Yes, but the mens rea element, which is what the inquiry is about here, we have the evidence of what he said, that his intention.
But we also have the evidence, Counselor, but we also have the evidence of what he did. He put one person on fire and he tried to put another one on fire.
Right, but you have to consider what he said in terms of the operation of his
After the event.
I mean, no,
to
not
consider
after
what
the event. No, the entire confession is just an irrationality. The reason that he thought that he had to hurt them was irrational. Okay, we're talking about someone who operated from a very profoundly disturbed mind, but in his mind he was going to hurt them. And since the law punishes the defendant's intent, if he stated that his intent was that.
So, Counsel, are you saying that if someone commits a robbery and intended only to display the gun but not fire it, and the gun fires and kills someone, that person should be found not guilty of intending to kill because that wasn't their intent? That's, I mean, your argument would go to that, quite frankly, ridiculous extreme.
Yes, but in this case, we have direct evidence. In that case, that might not be credible, but here what I'm saying is in the context of who Mr. Diaz was, what he said in that 53 minutes, it is credible.
This is Judge Gish. Didn't the jury have the right not to believe that? I mean, you look at it, you intend the natural consequences of your acts. And certainly you could conclude that by pouring gasoline on somebody and trying to put a lighter to the gasoline, that you intended to kill them, regardless of what you say. Couldn't the jury just say, that is not believable?
The jury could, but our position is that that's against the weight of the evidence and it's legally insufficient.
Did your client
I don't
have
know
with
why.
him any equipment to put the fire out?
No, he did not intend to put the fire out. He in fact, after he set his wife on fire, he went, because his plan was upset, he went to the second locus and tried to set another person on fire.
So you're saying he did not intend to kill these people, but brought with him only equipment to start fires and nothing to stop the fire.
Yes, and what I'm saying is in his mind, and we're talking about his mind, not our minds, which might see it quite differently, as you've all pointed out, but in his mind, he didn't intend to kill, and my argument is that that's what's operative.
Thank you. You'll have time on rebuttal.
Thank you.
Ms. Schlossberg?
It is the court. Good afternoon. I'm Karen Schlossberg on behalf of the people. I think it's obvious, as I think the questions here show, if a jury hears evidence that a defendant walks up to his ex-wife, who, by the way, he's been threatening to kill for years, stands a foot and a half from her and sprays her with accelerant and then uses a blowtorch to light her on fire, watches as the flames engulf her head and upper torso and then leaves her for dead, he can't later render that evidence that clearly shows his intent to kill her insufficient by telling police officers that he didn't mean to kill her. That's not how evidence works. The jurors were clearly entitled to find that he intended to kill her, and when he went to the auto body shop, that he also had been threatening to burn down, and poured 2 gasoline containers full of gasoline all over the furniture on the floor, and then doused his former boss with that gasoline and tried to light the entire place on fire. The jury was surely justified in finding that he was guilty of the arson and attempted murder in that case as well, despite his later claim that that was not what he intended to do.
Counsel, this is Judge Mendez. Had he threatened the shop owner also with bodily harm before he went to the shop to set it on fire?
As far as the evidence shows, Your Honor, he had only threatened to burn down the shop, but the evidence, he had threatened many times to burn down the shop and you're not going to be allowed to continue without me and that sort of thing. But the evidence was that he, after dousing the floor and the furniture, he then doused the man himself, and the police officers were clear. Mr. Merchant didn't just have a sprinkling of gasoline, he was entirely covered in gasoline. He was completely wet. So I think the inference that the defendant intended to kill him as he burned down the shop was well justified by the evidence. Unless there are any other questions on this or on the 730 issue, which was not addressed, I'll rest on the arguments set forth in my brief.
Thank you so much. Counsel, you have 1 minute on rebuttal.
Yes, I would like to address the 730 issue. Mr. Diaz's due process rights were violated because he was tried as a competent person when in fact there were grave doubts and ambiguities about that. Dusky requires a sufficient present ability to consult with the attorney and to have understanding of the legal proceedings.
Wasn't there an issue of malingering, and the experts who supported that there's an incompetency did not do tests about malingering, but the expert who said that he was competent did do?
Well, but the expert who did consider the malingering, Dr. Sirich, he did consider the malingering and he did not do the tests. But the point is that even if the possibility of malingering was there, he determined that all of the clinical findings, the clinical presentation, the 2,000 pages of Riker's records, everything.
Yeah, well, so Dr. Rioja listened to the defendant's Riker's Island telephone calls, right, and found that they were appropriate.
And Dr. Rioja also conceded that competency is fluid and dynamic, and you see that in the Riker's records. And counsel, in addition to telling the court that Mr. Diaz had a complete inability to assist in his defense, that he didn't understand that he faced a life sentence, that he could not meaningfully discuss the plea, which was offered of 15 to life, and now he's serving a sentence of 35 to life. And counsel also raised the issue of staleness, that both of these, the 730 report and the People's Expert report, were months in the past. And she asked the judge for a contemporaneous competency hearing.
But was there any basis for further causing yet another delay on this trial? Was there any factual basis to show that the defendant was exhibiting any signs of mental decompensation that would have warranted a new 730 exam?
Yes, counsel stated to the court that he had a complete inability to discuss the plea. She couldn't discuss the favorable plea with him. She couldn't discuss anything. He completely didn't understand. I should say that he had no criminal background, and he came from a country with a completely different criminal justice system. Dr. Sirich,
what country is that?
The Dominican Republic.
The system is not that different, counsel.
Well,
what does that have to do with competency?
Well, because he had no basis, because Dr. Sirich and even Dr. Rioja said that he lacked a basic understanding of legal principles. What I'm trying to point out is that there wasn't even any background for him to grasp these principles apart from the disability.
But that's not competency. Let's not get them mixed up.
No, it is competency. It is under Dusky.
That's mental competency?
Yes, under.
I come from a country where they have a different legal system, and therefore that affects my competency?
No, that he couldn't understand.
But wasn't he
proceedings?
Wasn't he able to, in one of those Rikers conversation, wasn't he overheard actually speaking about the offers that he had been made by the district attorney's office?
Yes, and in fact, those offers didn't exist. The offer that existed was there was only one offer of 15 to life, and he was talking about offers of 22 to 25. This didn't exist. He invented it.
So he was never offered 22 to 25?
No, he made it up. And everyone just assumed that he knew what a plea was. He didn't. He didn't understand it. Counsel said that she never communicated a plea offer of 22 to 25. That's only one of the many things that are documented in our brief from the reports. And even when he talked to the people's expert, Dr. Rioja, he still showed that a complete lack of knowledge. He said that defense counsel could help him if she knew witchcraft. He said the same thing to Dr. Sirish, that he thought that defense counsel was someone who could help him against the devil. He had absolutely no idea of what was going on. And in terms of them lingering, Justice Friedman.
All right, counsel, I'm going to ask you to wrap it up. We are well beyond your 1 minute.
Right. Even if he were malingering when Dr. Rioja gave him the test, that is not sufficient to deny him a competency hearing. In Cooper v. Oklahoma, the Supreme Court.
Thank you. We will take a look at your briefs and the record. Thank you so much. You are way over time.
Thank you very much.
Thank you. Del Valle versus 1733 Unico.
Good afternoon, Your Honors. Beth Gehrig for the defendant appellant.
You may proceed.
Thank you. We're asking this court to reverse the trial court's decision denying summary judgment to our clients because of two gross errors in the decision. First, the motion was denied based on a condition which was never pled, supported by the affidavit.
This is Judge Gish. Let me just stop you there. Isn't the condition which is the basis for liability a wet floor?
Yes.
Okay, does it matter how it became wet?
Yes.
Why?
According to the judge, the trial judge, it was. According to the trial judge.
Well, how about according to us? I mean, according to law, because now we're up on appeal. And your argument is that the plaintiff was inconsistent about the source of the water in the stairwell. That may be, but what does it really make a difference in the case? Does it matter what the source of the water was, considering both her explanations were infiltration of water through the windows?
2 points.
Whether they were broken or leaking or open.
Well, 2 points, Your Honor. First, according to the plaintiff, she wasn't inconsistent. Plaintiff was unequivocal that the reason why the water came in was because of an open window.
Okay, so she was mistaken based on the video, but that doesn't change the condition of the stairwell. So, I mean, we need you to focus on that.
Absolutely. When she talks about the water that's on the stairwell, she talks about a minor amount of water, a little bit that was tracked in from other people due to the inclement weather. We have here in the video, you could see our porter cleaning the area an hour and 15 minutes before. And therefore, we show that we did maintain it properly. And as the trial court found, that water being tracked in due to inclement weather is not an actionable condition. But just jumping back to the case relied on by the trial court, the Tavares case, in that case, when they were talking about the fact that there was a leaky pipe, that was something that was addressed all along by the plaintiff at the 50H and in the testimony. Here, by allowing the plaintiff to now claim a broken window, which was not pled, which she testified unequivocally at her deposition. She was not claiming it was broken. She was claiming it was open. We were severely prejudiced because there was no way we were able to address that when bringing our initial motion. At some point, we have to be able to trust what the plaintiff alleges. So if we have plaintiff's testimony saying the window's open, that's how it got there. The window was not broken. We have the plaintiff's bill of particulars only alleging water on the stairs. And it looks like initially they were trying to claim that it was due to mopping because in the notice, the response to the notice claim, they said it was a condition that we created. And if we can't believe their discovery submission, where they tell us there are absolutely no notice witnesses.
Let's talk about that. Wasn't it your client that produced the video?
Yes,
And in that video, aren't these witnesses readily apparent? So why are you surprised by the statement of witnesses that you can see in the video that you produced?
that cuts both ways, Your Honor, because those are pictures.
But what it does do is absolutely prevent you from arguing surprise. You can't say you're prejudiced by something that you are completely aware of.
Respectfully, Your Honor, there's a big difference between a witness to an occurrence or a witness after the fact and a notice witness. They're claiming these people were notice witnesses, so that's something prior to the
Do
incident.
we have any idea when they realized that they were notice witnesses?
According to plaintiff's counsel, he didn't realize that until he was served with the motion for summary judgment. Now, they had the video. So if they had the video, why wasn't it their burden to go and speak to these people? Because they were the ones that had the obligation to notify us whether or not these were notice witnesses. They said there were no notice witnesses. At some point, we have to turn.
It was your motion, though.
Absolutely.
It's your motion, so you have the burden.
We have the burden of addressing the claims that they made in their complaint and their bill of particulars. And
That's
their
right. Counsel, you can't close your eyes and pretend to not know about people who may be witnesses who are tenants in your own building. There's no excuse for that.
Your Honor, taking
the same way the plaintiffs could use that video to go and talk to the people they see in the video, so could your client.
If they were people that were there as fact witnesses to her falling, or
and only if you talk to them will you know the answer to that question. And that's not on the plaintiff to do it for you.
Your Honor, taking that to its illogical conclusion, then we should have questioned every single person who lived in that building to see if they had complaints about a condition that plaintiff never even alleged. There's a big difference between water being tracked into a building and a broken window.
Is it not? Doesn't this record reflect that there were multiple people who said that on multiple occasions they complained about a recurring wet condition on the stairs?
They claimed that they were aware of, they didn't say they complained, they claimed that they were aware of the window leaking, but that's not the claim that's made here. As a practical matter, what happened here is they served the bill of particulars alleging that somebody was mopping and we created the condition. Then they claim in the bill of particulars that the condition is, their client testifies at her deposition after she's seen the video and acknowledges it, that it is an open window she's claiming. An open window. She's asked, was it broken? She said no. Then in response to that,
wait, let's just stop for a minute. The broken window was on the landing above, wasn't it?
Correct. Yep. Well, she says it's not broken. Her testimony was that it is not a broken window.
The window where she thought it was open wasn't broken.
Correct.
But above, the landing above, there was a claim. She said, gee, that was broken.
No,
and you talk about water being tracked. Doesn't it make a difference about water being tracked in from the outside as opposed to water that comes through windows and it's tracked down the stairs?
If it was true that the window.
I'm not saying that. I'm not questioning whether you have defenses here. I just my head scratch on this case is why summary judgment really. That's really it. I think it's a hard summary judgment.
All right, and you'll have time on rebuttal, counsel. We've gone over by about 3 minutes. Okay, so you'll have a moment on rebuttal. Counsel for respondent.
Good afternoon, Your Honor. Kenneth Gorman for the plaintiff respondent. All of the arguments that my adversary raises become academic because the defendant moving for summary judgment on the grounds that it had no notice of a dangerous condition has to show that the dangerous condition did not exist when the area was last inspected. And since the defendants failed to submit an affidavit from anyone who inspected the area prior to plaintiff's fall, they failed to meet their burden for summary judgment.
Well, doesn't the sworn testimony of Mr. Baez count for anything? You don't necessarily need it in the form you're saying. You know, he did say, I recall that day I inspected and there was no water. Why isn't that enough?
Because we have
For
a video.
prima facie case, at least.
Prima facie, yes, but it's uncontested.
You mentioned you have a video, but doesn't the video show that defendant's employee was sweeping the area?
That's true, but there's two arguments with regard to that. Number one is that we don't have an affidavit from that employee as to what he saw when he swept the area, and number two, a defendant
What does the video show?
Video shows him walking up and superficially sweeping the area, but a defendant can't cure a deficiency in their papers by relying on a videotape that plaintiff submits.
I mean, you don't think a picture is worth 1,000 words?
True, but I mean, a party for moving for summary judgment cannot satisfy its initial burden of proof by relying on evidence submitted in opposition to their motion. But regardless, we have plenty of evidence that these stairs were wet. They were not properly maintained.
And do you have evidence as to the cause of the wetness on the stairs? Or do you even need it at this point?
Well, number one, we don't need it because they failed to meet their burden. And number two, we have
Well,
several.
let's assume they did meet their burden.
Well, we have the plaintiff's father who testified at his deposition at page 517 of the record that the window was open the night before. He testified that it was his opinion or belief that the water came in through that open window. And we don't know how long, even though the video shows that it was closed, we only see that window for 2 minutes. With regard to the video that the defendant submitted in support of the motion for summary judgment, we don't know how long it was open for before that, when it was closed. We just don't know. And we have 5 witnesses who testified or submitted affidavits that there was a recurrent condition which consistently permitted the stairs to become wet every time it rained or snowed.
Okay. Thank you. Any other questions? Thank you, counsel.
Thank you, Judge.
All right. You have 1 minute on rebuttal.
On rebuttal, as Justice Freeman pointed out, a picture is worth 1,000 words. And the video here shows that the window that plaintiff attributes to her fall was closed.
Well, how do you address counsel's argument that they have at least raised an issue of fact about whether it was open sometime shortly before that, in view of the fact that it's uncontested that it rained the night before?
Because both the plaintiff and her father got a little wishy-washy when he was asked and finally admitted he didn't remember if that window was open or not.
But isn't wishy-washy just credibility?
Absolutely, but that's their witness. They're the ones that subpoenaed him, and they're the ones that are using the testimony for their benefit.
But all they have to do is create an issue of fact.
However, Your Honor,
we're not trying the case now, right?
I understand, but here, as much as we're focusing on the issue of notice, the Court of Appeals in Hutchinson made it perfectly clear that when the condition that's alleged is trivial, it doesn't make a difference on the issue of notice.
We don't have any proof whether it's trivial or not here.
We do.
We really don't. All right. All right. I think I understand your arguments. We'll see.
If I may, just one more second, if I could ask you to please look at pages 126 to 129 of the record, where plaintiff describes the water on the stairs as a little bit and just footprints. Footprints are not something that's actionable, and that's something that was found by the trial court. The trial court clearly said that water that's being tracked in by inclement weather is not an actionable.
It's silly to tell us what the trial court said. We're here to review that. Okay, thank you.
Thank you so much. All right. Sen versus GR Realty. Judge David Friedman is recused from this case. All right, counsel, I will hear from the appellants.
Good afternoon, Your Honors. Roberta Kaplan for the appellants. Your Honors, this case is an appeal about specific jurisdiction under New York's long-arm statute. The trial judge in this case, presumably moved by the truly terrible circumstances, stretched the law in ways that are not only in error, but will have consequences far beyond the case. First, Your Honors, it is black letter law that for section 302A2, CPLR 302A2 to apply, the defendant must be physically present in New York when the tort occurred. Here it is undisputed that our clients were not. I don't think this one is even a close call, so I'm not going to belabor the points. Second, Your Honors, the trial court was also wrong.
Go ahead, continue.
Was also wrong to rely on 302A4. That is the last subsection of the long arm statute, which comes into play in connection with the ownership, use, possession of real property.
The lease qualifies for that, right?
No, it does not, Your Honor.
Well,
There has to be.
there has to be a nexus of the cause of action to the lease, but a lease can be the basis for jurisdiction under that subsection,
If it is
right?
a dispute about the lease, if there were dispute here about the terms of the lease, yes, then 302A4.
So here's the question for you, actually.
Yes,
I agree, the terms of the lease would certainly confer jurisdiction under that section. But if the cause of action is something that concerns premises liability, concerning the demised premises, wouldn't that section otherwise equally apply? And shouldn't it apply? Shouldn't it be applicable? Because if you lease property in the state, shouldn't you be responsible for premises liability that arises, even if it's a tort, on account of that subsection?
Okay, so let me answer that question as no and no, Your Honor. There is no reported case that the other side can cite to allowing for a negligence action, which I think is what Your Honor is talking about, under 301A4 simply by virtue of the fact that the tort occurred in, near, or on the property. In fact, there are a number of cases that go the other way, and all the cases that the defendants cite either reject jurisdiction in a personal injury action or accept jurisdiction in a case that's truly a real estate case, a fight about rent, a fight about a conveyance, a fight about a sale. That's what this statute has always been about. It's what the cases consistently have said it's about. And I would respectfully say that the reason there's such a dearth of case law on this is for that reason. If the law was to be interpreted the way they suggest, there would be tons of cases under 301A4 because it would be.
Well, would you say that is that a bad thing? I mean, if there's a nexus to the demised premises.
As the Court of Appeals made very clear in the seminal case of Feathers, your job is not to decide whether the legislature could have enacted legislation providing for jurisdiction. Your job is limited to whether the legislature did. And here, it's quite clear from the text, the use, and every single reported case that's out there that 301A4 applies to disputes about real estate.
May I interrupt you for a moment? Am I understanding correctly, if I'm following your argument all along, that because your clients were not home, that it takes it out of 302A4?
No, that's A2, Your Honor.
That's what?
That's only relevant for A2. For A2,
Okay.
The defendant has to be in the state of New York, and there's really no question that they won't.
Except that what you're suggesting is that in this scenario, assuming they were residents of New York, let's take the A4 situation out of the equation. You're suggesting that if they were residents of New York, owned this penthouse, had these lounge chairs not weighed down, and it went flying off as it did, hurting someone below, that if they were not home, they would not be liable?
No, they have to be within the state. For A2 jurisdiction, for a tort that occurs in New York, to have jurisdiction over someone.
That doesn't even make any public policy sense. So we are going to leave people potentially harmed simply because someone wasn't home. What happens to the responsibility of a homeowner to make sure that items on their terrace are secure so this doesn't happen?
So Your Honor, with respect, again, the Court of Appeals made it very clear in Feathers that it's not a public policy question for this court. You have to look at the language of the long arm statute. A2 has always been applied to mean what it says. It says commits a tortious act within the state. Within the state means that the defendant has to be in the state when the tortious act occurs.
I have a real hard time accepting that analysis. I have to tell you.
I don't know what to say, Your Honor, other than that's the way it's always been interpreted by courts, including numerous times by the Court of Appeals.
That doesn't, leaving the state does not relieve a homeowner or a property owner of their obligation to maintain the property of a home in a reasonably safe manner.
There may be a thing.
That obligation exists all the time.
There may be an obligation and there may be a cause of action against our defendants in California. The question is whether the state of New York can exercise jurisdiction. That jurisdiction.
Yeah, I know what the question is.
It has to come, Your Honor, from the long arm statute. And the only two ones are, one, torts when people are in the state clearly doesn't apply here. And two, the real estate section, which has been limited consistently and uniformly to disputes about real estate. The fact that this isn't a dispute about real estate is really the whole theory of their case. The theory of their case is that a chair fell off the terrace. It's not like the terrace fell on her. It was a piece of furniture. If you were to extend A4 to these circumstances, then someone living in another state could sublease their apartment. Someone in the apartment could fall on some spilled wine, and the state of New York would have jurisdiction over the original owner.
I really don't think you're trying to compare a lounge chair falling on somebody's head and causing severe brain damage with somebody slipping on wine.
I'm talking about the limits of jurisdiction.
Okay.
I said over and over what happened to her is tragic. There are
All right.
defendants here.
In either case, we are out of time and you'll have time on rebuttal. Counsel for Union Square, you have 3 minutes.
Good afternoon, Your Honors. May it please the court. My name is Amy Bedell for respondents 15 Union Square West Condominium and Brown Harris Stevens Residential Management. It's our position that on this appeal, the court need go no further than subsection A4 and the arises from element. Of course, we all agree that the tenants use and possess the real property. And in order to establish the arises from element, there need be a nexus, a relationship, a relatedness between the plaintiff's cause of action, here negligence, premises liability.
This is Judge Gish. Is your adversary right that there are no reported cases that extend A4 to A4 to, or A2, excuse me, you know which I'm talking about, A4 to negligence cause of actions, notwithstanding that they may have a connection to demised premises or to the premises at all, to real estate?
I have two answers to that question, Your Honor. One, there is a lack of case law, yes, but that is because, as the practice commentaries have stated, the connection in those cases is obvious. The question, like here, is can the plaintiff maintain this negligence cause of action against the tenant defendants, irrespective of whether the tenant defendants own and use the real property? The answer to that question establishes the arises from element. The answer to that question is, of course, yes. But for their use and possession of the property, the tenant defendants wouldn't be here. Now, the fact that the tenants cited real property transaction disputes, that's because in those cases, there were questions that required to be litigated. Here, it's I dare say, obvious that the negligence cause of action arises, but for
it's a negligence maintenance of premises, of the premises themselves.
Right, Your Honor.
Anything else?
I will just add due process. The due process issue also is very clearly met. In addition to the number of contacts that the tenants have, that we set forth in our brief, by the satisfaction of A4 alone, their use and possession of the property.
Right, the due process is actually easier in this case than the statutory. The least, they're in the, yeah, for me anyway.
The privileges, the benefits, the protections of the law granted upon the tenants by the state satisfy the due process requirements.
Thank you.
Thank you.
Okay, counsel for plaintiff.
Good afternoon, Your Honors. May it please the court, I'm Sarah Mahoney from the Marley Law Firm on behalf of Plaintiff Annabelle Sen. The tenant's personal jurisdiction arguments offered in this court are both legally and logically unfounded.
Can you address the Feathers case? Does that unequivocally say that the defendants need to be physically present at the time of the tort?
Well, Your Honor, so several courts have said that Feathers does not unequivocally say that and have found that physical presence is not necessary. And in fact, this court in the Banco decision, it affirmed the trial court's lower court's decision and held just that you don't have to have physical presence. We argue that the Feathers case and the other A2 cases that the tenants rely on here are inapplicable and distinguishable because in the majority of those cases, the defendants never even set foot in New York. And in all those cases, including Feathers, there was no tortious act in New York. Here, however, we have renters who took possession of a New York apartment, spent at least a week there every month during the tenancy of their lease, and failed to maintain their property in a reasonably safe condition. So we say that under those elements, the Feathers rule doesn't apply because, as your honors have already said, a tenant has a duty to keep their New York property in reasonably safe condition, no matter where they are in the world. Their duty doesn't pause just because they leave the state.
Yeah, but duty and jurisdiction are different, right?
Yes, Your Honor. Yes, and that's an important distinction because I think what the defendants are overlooking is this is a motion for, a motion to dismiss. We have to accept all of the allegations and plaintiffs pleading as correct. A lot of the cases the defendants cite, the property cases the defendants cite, are on a motion for summary judgment after.
But in a way, that doesn't really make a difference. I mean, you're not claiming that the defendants were in town when the lounge chair took off like a projectile off the terrace. You don't dispute that. It's not a disputed fact.
That is what they say in their affidavits. But again,
when you move on jurisdictional grounds, they're allowed to put in some facts regarding jurisdiction. You don't have anything in your, I mean, when you talk about, giving deference to your pleading, there's nothing in your pleading that's one way or the other about that.
That's correct, Your Honor. But again, what is in our pleading is allegations that the defendants failed to maintain the property in a reasonably safe condition.
Right, duty. Right.
Exactly, right. And Your Honor, I would also remind you that we don't even have to get to an A2 analysis in this case, because as my co-respondent said, the application of A4 in this case is obvious. And that's why there's not a lot of cases on A4 applying to property cases, because it's obvious. And I would like to address Ms. Kaplan's argument that A4 only applies to real property disputes or real estate disputes. That's not the law. And in fact, numerous courts, including this court in the Lancaster case, the Hopstein case, the Second Department, the Zeiden case in the Fourth Department, and Wang and the ED&Y, those are all negligence cases. And in those cases, the courts addressed whether A4 applied. And if it were the law that A4 can only apply to real property disputes, then those courts would have said so, and they would have ended their inquiry there. But they didn't say that. What they said was, or what they did was analyzed whether the particular New York property in those cases had a relationship to the plaintiff's claims. Now, in those cases, it happened to be there was not a relationship between the property and the plaintiff's claims. But again, if it were the law that they only apply to real property disputes, all those cases, all those courts, including this court, would have said so. There's no case that says that. And additionally, as we've mentioned briefly, we do believe the due process requirements have been met in this case. The tenants obviously had minimum contacts with New York. They obviously could have and should have reasonably anticipated being hauled into court in relation to their rental of a New York property. And so for all these reasons, the requirements of the state's long-arm statute and due process have been satisfied here. And we believe the Supreme Court's order as to personal jurisdiction should be affirmed.
Thank you so much.
Thank you.
Three brief points, Your Honor. I heard the other side say that the reason there are no reported cases ever holding A4 liability in the context of real estate is because it's so obvious no one has to think about it. Your Honors, we all live in New York. People litigate a lot in New York. If it was so obvious that A4 applied to negligence cases in, near, or around property, there would be a lot of reported cases. And as you heard my friend freely admit, in every case in which the matter has been raised, jurisdiction has been denied. There's not a single reported case in the state of New York upholding jurisdiction in a negligence case under A4 because it was somehow just related to the property. All negligence happens in, near, or on property, number one. Number two, with respect to the cite that Ms. Mahoney gave from the Banco case, that case, by its very terms, is explicitly limited to computer transactions where it's very, very hard to determine where the parties were. And if you look at that case, the court says we have to do it here because otherwise we're ignoring the reality of modern banking and computer technology. There's no modern banking and computer technology in this case. It's a straightforward negligence case, old fashioned. We know where the people were and we know that they weren't in New York. Finally, Your Honors, I understand fully how you're struggling with the policy implications on this. I would say three things. One, there are other defendants in this case, including the building and the building manager and the owner, all of whom live in New York, and there's no jurisdictional question. Two, our clients certainly could be sued in California for this case. And three, most importantly, I implore you to look at the language of Judge Fuld in Feathers. That's at 68 New York 77, 68 New York at 77. Judge Fuld, not exactly, not a very esteemed judge, where he says that when you're analyzing questions of their long arm, you're not to look at policy. You have to look at what the statute says. It's up to the legislature if they believe in policy to extend the terms of the long arm statute, and they have not done so here. And for you to do so here would be vastly expanding the law of the state of New York in these areas.
Thank you. Okay, Alvarez versus XL Specialty. And counsel, let's just wait for Judge Friedman to return on camera. Okay, you may proceed, counsel.
Good afternoon, Your Honors. May it please the court, Alexis Rogoski for the appellant XL Specialty. Under this court's jurisdiction addressing interrelated claims provisions, the adversary proceeding is a single claim.
I want to ask this, Judge Friedman, on page 195 of the record is an amendment to the exclusions, which says defining the portion of before the word claim, and that provision is set forth on page 196 of the record. How does that amendment play into this appeal?
So that is a point of sharp dispute between the parties, Your Honor, probably not surprising. XL's view is that in the first instance, you need to look at the interrelated claim provision. That endorsement does not amend the interrelated claim provision. That provision, reads as stands, and it provides that all claims arising from interrelated wrongful acts shall be deemed to constitute a single claim. It was not amended. And in that connection, Your Honor, it's pretty standard law in New York that exclusions don't create coverage, and you don't interpret coverage by reference to exclusions.
So maybe this takes us to an ambiguity in what's covered and what's not covered. And why doesn't that work against you as the insurer? If there is an ambiguity, don't we interpret it against you here?
We don't believe it creates an ambiguity, Your Honor, because again, the endorsement does not modify the interrelated claims provision. But I can
when the 2015 action was settled, the settlement didn't talk about the Land's End spinoff, did it?
Well,
the recitals didn't mention the Land's End spinoff.
Well, Your Honor, there's two points there I would like to make. First, the Rosoff claim, which is the original complaint that contained the most allegations about the spinoff, clearly satisfies the definition of claim in the policy. It was a civil proceeding. And the application of the interrelated claim provision depends on claims, not whether a lawsuit is
So
withdrawn,
you're right.
dismissed.
You're right that the Russoff complaint in the Delaware Chancery Court does make mention of the Lanzoff spinoff and the ESL loans. So you're right about that, but yet it doesn't get into that. And correct me if I'm wrong.
No, I would make a
the
further
request for relief. It doesn't get to that.
Well, let me answer the previous question a bit further, Your Honor. In the settlement agreement, in the recitals, and it's recital D, and it's page 1555 of the record, it specifically refers to each of the original actions, and it defines them as original complaints. And then in the definition of released plaintiff's claims on page 1565 of the record, it specifically provides that the plaintiffs are releasing all claims asserted in any of the original complaints. So although it doesn't mention, the release recitals don't mention the Land's End spinoff, they are addressed through other provisions in the settlement agreement. And your question is the Russoff complaint. If I can find the page, give me one moment.
I think it's page
Russoff,
940. Are you thinking of page 940?
yes, 940 to 941. They say the directors and controlling stockholder ESL also violated fiduciary duties. And there's a list on page 941 of 5 bullet points. And one of those bullet points is the Land End spinoff. So they are making a claim of breach of fiduciary duty based on the Land's End spinoff in the Russoff complaint. And that is one of the claims that was released by the settlement agreement, by the specific incorporation of that agreement.
This doesn't, what you point to on page 940, it doesn't sort of end up, does it? Again, I'm ready to be corrected if I'm wrong, into the amended complaint, which is dated July 19th, 2016. It doesn't quite go in there the same way, does it?
Your Honor is correct that when the consolidated derivative complaint was filed, the plaintiffs made a judgment not to carry that transaction into the consolidated amended complaint. But that goes back to my point I was trying to make earlier, that when you're comparing whether an earlier claim was made, how that claim was resolved, whether it was pursued, whether it was abandoned, whether it was dismissed, whether it was settled, whether there was a judgment, is not part of that analysis. You look at the allegations that were made and whether the allegations in the later proceeding are related. And I wanted to make one further point about the exclusion that Your Honor raised, because even if you're troubled by the exclusion, I would ask you to look at the language of that exclusion carefully, because although the introductory language was amended to read that portion of any claim, the exclusion still goes on to say, based upon, arising out of, directly or indirectly resulting from, in consequence of, or in any way involving any fact, circumstance, or situation. So even though the introductory language was modified, you still have to undertake an analysis of whether, for example, the related party loans were undertaken as a result of or in consequence of the Seritage transaction.
I know that exclusion reads about as well as it possibly could for you, but then you get to the problem about the amendment on page 195. So what was contemplated when this amendment was entered into?
Which amendment? I mean,
about the any portion of any portion
right.
of.
Well, it obviously it narrows the prior notice exclusion, but notwithstanding that, Your Honor, you have to analyze whether the related party loans were in consequence of the Seritage transaction. Even with that language, you still have to make that analysis. And it's our position that when you look at the adversary proceeding allegations regarding the related party loans, the creditors committee clearly sets forth that those loans resulted from and were in consequence of the Seritage transaction because they were intended to keep Sears afloat so that Sears could keep making lease payments to Seritage so that the value of the Seritage shares would not tank, so that over time, Seritage could reacquire properties from Sears, redevelop properties from Sears, and be in a position where it didn't need Sears to continue as a profitable business. And in fact, the creditors committee asserts that once Mr. Lampert and ESL and the other insiders had accomplished that goal with Seritage, they stopped making related party loans.
Okay, you'll have additional time on rebuttal. Okay.
Thank you.
Mr.
Good afternoon, Your Honors. Brian Gluckstein, Sullivan and Cromwell on behalf of the respondents. Your Honors, we submit that as the court below found that both policies provide coverage in this case. The 2015-16 policy with respect to the Seritage claims, the 2017 to 24 policy with respect to the remainder of the complaint. And we do submit that the analysis begins, as Justice Friedman indicated, with the 2017-24 XL policy, which is a claims-made policy that presumptively provides coverage for this 2019 litigation. And on that path, Your Honors, the key issue is whether the prior notice exclusion in the policy excludes any of the counts in the complaint from coverage. And I don't think there's any question under these circumstances that there was language added even beyond the interpretation, which I'll get to in a moment, of how claims are defined in the policy. As Justice Friedman alluded to, only a portion of the claim that was previously noticed is subject to the exclusion. So, Your Honors, we certainly submit that under that analysis, claim-by-claim analysis is required, and that the Seritage claims are the only portion of that to relate back.
I know that endorsement is certainly, that's maybe it's your ace in the hole, but it doesn't all go your way, because what do you do with what's on page 620 of the record when you get to the amended complaint in Delaware Chancery Court, paragraph 51? It does make mention to specifically the board approved the divestiture of certain of SHLD's shareholdings limited assets, including its land and Sears Canada businesses. So you still do have Land's End mentioned in the amended complaint. It doesn't disappear completely from purview.
Your Honor, with respect to the amended complaint, and we did think there's a critical threshold issue with respect to the Land's End transaction. And the first argument I'd make in response to Land's End, Your Honor, is that, and you're right, as you alluded to earlier, the Land's End transaction is not part of the settlement. It's not part of the litigation. It is referred to in effectively a recital as recapping facts that took place. There's no indication that there was claims prosecuted or settled with respect to Land's End. But Your Honor, as a threshold matter, the claims that are asserted in the Rossoff complaint that was in fact superseded and was not the complaint that ultimately was litigated in Delaware, that claim asserted an entirely different and opposite theory from what is asserted in the bankruptcy litigation. The assertion, to the extent there was one in that original Rossoff complaint, is that the transaction was unfair to shareholders, while the underlying complaint in the bankruptcy case that we're now defending and that's subject to the coverage in this lawsuit alleges that the spinoff was in fact designed to benefit shareholders and Mr. Lampert at the expense of Sears and his creditors. And Your Honor, I would submit this is precisely the same scenario that this court addressed in a similar coverage dispute in the American Casualty Company v. Gelb case, 18 New York 3rd 30, where two proceedings arose from the same merger, but they were held not to be related claims because in an earlier policy because they were premised on opposite legal theories. So we would submit as a threshold matter, Your Honor, that these are not the same claims just because the fact that Land's End is mentioned. But it goes further than that. As the court below analyzed, as we put in our papers, Your Honor, just because there's a mention of the Land's End transaction, that does not make the Land's End transaction which was in a different period of time, involved different assets, different consideration at issue in the claims that were insured by XL in the 2015 derivative action.
I think your adversary said that there was reference to the spin-off in the settlement of that 2015 action. I wonder what your response is to that.
What I would respond to, Your Honor, on that is there is no express reference at all. There's a general release of claims, related to the litigation as a standard release. There is no discussion. And in fact, the settlement agreement and the proceedings before the Delaware Chancery Court go on at quite length as to what's at issue in the case, procedurally, how we got to the point of a settlement, and nowhere is Land's End mentioned. So yes, there was arguably a release to the extent of the scope of the litigation. And I would submit, Your Honor, in the underlying bankruptcy litigation, where there is litigation ongoing about the enforceability of those releases and the scope of those releases, no parties, the insureds, the plaintiffs there, or anybody else has suggested that the Land's End claims are released. They, in fact, would be under XL's arguments here. And I think it's an important point, Your Honor, because if you look at what XL wants to do here, is they want to collapse the entirety of everything that happened with respect to Sears into a single cause of action that relates back to the 2015 policy, effectively precluding that there could be any claims asserted that would be covered against directors and officers having any allegations with respect to events that led to the financial downturn of Sears could be covered under the later policy, for which, of course, they were paid separate premiums. And we would submit, Your Honor, that the case law on that is clear, that where there are attempts to simply suggest that everything was a macro plot or an ongoing conspiracy, that courts in this state view that very narrowly. And the mere allegations that this is all linked together is certainly not enough to relate back to an earlier cause of action. And in fact, XL admits as much in its reply briefing that its position with respect to all of these claims being intertwined in this way is actually not only at odds with the respondents' views, but with the plaintiffs who drafted and filed the complaint. They say that in footnote 3 of their brief.
Thank you so much. We're out of time.
Thank you, Your Honors.
Thank you. Counsel, you have 2 minutes on rebuttal. Please stick to those 2 minutes.
Yes, Your Honor. I just wanted to return again to the release. It's plaintiff's release claims. It's the release of the consolidated derivative litigation. It's very broad language. And not only do they include the matters asserted in the consolidated complaint or the consolidated amended complaint, but in any of the original complaints. That certainly includes Land's End. Now, for whatever strategic reason, the defendants in the adversary.
Was there a cause of action in that original action specifically directed towards Land's End?
It was the cause of action we discussed previously, Your Honor, where they alleged breach of fiduciary duty, and they had 5 bullet points identifying the transactions that they contended were a breach of fiduciary duty, and that was at first claim for relief. Count 1, breach of fiduciary duty, that begins on page 939 of the record, and the bullet point transactions that they contend were a breach of fiduciary duty on 941. And the point I wanted to make, Your Honor, is that the claim in the adversary proceeding with regard to the Seritage settlement was that it was settled too cheaply. So there were strategic reasons why the defendants might not want to stress.
Counsel, let me ask you this. So
sure.
I hear you, the points you make, that it did include the Land's End spinoff, et cetera. But where would I be going wrong in saying that this complaint was, the focus of it was really Seritage?
As the action moved forward, the focus was Seritage, but again, the claim was made and the claim was encompassed within the release. And further, Your Honor, I want to go back to the point that when you look at the related party loans, it's alleged that those loans were a result and a consequence of the Seritage transaction and the defendant's need to keep Sarah Charge alive as a viable concern until they could.
When did those loan
reposition
transactions arise?
They arose after the Seritage transaction because, again, it's alleged that
when did it arise vis-a-vis the commencement of the action in Delaware?
So the action in Delaware commenced in 2015. The loan spanned the period 2016 to 2018, and I believe the settlement was 2017.
So the loans arose after the action was commenced.
Correct, Your Honor. But again, the allegation is the loans were necessary to keep Seritage afloat until the defendants could reposition the stores, reacquire the stores from Sears, reposition the stores, redevelop the stores. And then at that point, they would no longer need Sears and they would no longer have to fund Sears. But there's a direct, but for.
You can finish that sentence.
Finished, Your Honor. Thank you for your time.
Thank you so much. All right. Protostorm, no. People v. Carlos Ramos, no, that's submitted. Protostorm Inc. versus Foley and Lardner. I was correct.
May it please the court. I'm Philippe Adler for defendants, appellants Foley and Lardner, and John Moskin, a partner there. We ask this court to reverse the denial of our motion to dismiss the complaint. Plaintiff Appellate Protostorm, Foley's former client, sued Foley and Mr. Moskin for committing malpractice in a federal action that was tried to a jury verdict. The malpractice consists allegedly of failing to seek joint and several liability against Carl Brundage and Frederick Bailey, who were defendants.
Well, it's not allegedly, they didn't, right?
That's not, I don't agree with that, Your Honor.
Okay.
So if we want to, so at the, before the verdict, there was no need to seek joint and several liability as the federal court itself found, because joint and several liability is a matter of law for the court and not a fact for the jury. Immediately after the verdict, in the motion practice leading to the October 2014 order and the accompanying original judgment, the federal court barred the lawyers, including Foley, from addressing the joint and several liability of Mr. Brundage and Mr. Bailey, and required them to limit themselves to addressing the joint and several liability of the Antonelli firm. And then on the first,
you're saying the court prohibited counsel from making the arguments they wanted to make on this issue? That's what you're saying?
Yes, Your Honor. I would direct the court to page 164 of the record, where the judge in the federal action says that the briefing that led to the original judgment is to be, quote, solely on the issue of reapportioning or reallocating the judgment against the two former 18.
I think I would like to, this is Judge Friedman, I want to ask you a question. I want to direct your attention to something which I think must have occurred before what you're referring to. And I'm speaking of page 219 of the record. Mr. Goodman, who's appearing on your side, although it's not from the defendant appellant firm, he was appearing for that side of the parties. So it says, Mr. Goodman, I would respectfully suggest that you read, I also instruct you that you must attribute the acts of the individual defendant attorneys to ATS and K. So one of the things I've tried to understand here, and after all, there was a reason why you would really want to see that Brundage was going to be on the line for any verdict that emerged here, because Brundage, after all, was a participant in a patent action, which resulted, he was a participant in a $600 million patent settlement. So you knew that Brundage is someone who has assets, and you've got to know that ATSK may not have more than its insurance, which you know is going to pay for legal fees as things are going on. So why does your side ask, well, the individual defendants should be charged to ATSK? From the get-go, this should have been tried on a joint and several liability theory.
Your Honor, first of all, as Your Honor noted, insofar as one could allege that this was negligent or malpractice, it is not my client's negligence or malpractice. We're not here on a comparative negligence based appeal, but this is a statement, as with all the statements.
So what was the relationship? So what's the relationship between Mr. Goodman, who I believe is of Mount Cotton, and your clients? I mean, you were all representing Protostorm, weren't you?
That's correct. We're all representing Protostorm, but the statements which are cited here by the district court and the statements that are cited by the Second Circuit later in finding waiver are uniformly statements made not by the defendants in this matter, but by defendants who settled out long ago, including Mount Cotton and Mr. Goodman. Now, to respond to your question about whether—
So let me see if I can I'm sorry, Judge Friedman, was your question answered, or can I ask something else?
I have another question, but you go first, and after you finish, I'll come back with my next question.
Isn't the problem here, isn't it, what the Second Circuit did? Because the trial court actually went on to consider the merits of joint and several, and she substantively said there was none. Maybe she was right, maybe she was wrong. The Second Circuit, however, didn't reach that because it said the defendants waived. Can we even look behind that, at least at this stage of the game, where the allegation is that a waiver of that claim would otherwise or could otherwise constitute malpractice?
Respectfully, Your Honor, I think the answer to your question is yes, because it's not really looking behind. The Second Circuit explicitly cited the portions of the trial transcript which, in its view, supported its finding of waiver. Those portions of the trial transcript are properly in the record before this court, and they show, without exception, that the statements being made were statements made by our co-counsel and not by us. I think the broader point is that when you look at the allegations of the complaint about what Foley did—
But wasn't there a joint theory or a joint strategy as to how this case was being tried?
I don't think that that's actually pled, Your Honor. I think what's pled is that there was a waiver and that we are being sued. The essence of the claim, according to plaintiffs, is the waiver, but plaintiffs make no effort to connect their allegations against Foley to the Second Circuit's finding of waiver. Their allegations against Foley are that post-trial, Foley was one of the law firms submitting letter briefs which allegedly made arguments that were too late in support of joint and several liability. When you look at what the Second Circuit says waiver is, it has nothing to do with—
So what you're asking, so one of your big asks for today is that we differentiate between Foley and Mount Cotton and say, well, everything that went on here is Mount Cotton's responsibility, and therefore you're off the hook on this.
In fact, Your Honor, we don't believe that we are here today on a comparative negligence type appeal. Our big asks today, to put it in Your Honor's terms, are that the court look at what was pled in terms of negligence.
This is a pleading motion.
Yes, what was pled in terms of negligence and what was pled in terms of causation. So in terms of
how in light of all these, and I understand it's a pleading motion, maybe at the end of the day, all of these things we're saying are going to turn out to have a different cast on them. But how on a pleading motion are we to decide now that, well, this is all Mount Cotton's business and therefore the action against Foley should be dismissed?
I'll go through it first as to negligence and second as to causation.
Counsel, before you go through it, you are way past your time already. So I will give you 1 minute to answer that question, and you can save whatever other reply you have for your reply time, okay?
Okay. As to negligence, which is what I'll focus on, it was not negligent not to seek joint and several liability before the verdict because it's a matter of law. It was not negligent to not seek joint and several liability in the lead up to the original judgment because we were banned from doing so. And in fact, the letter brief that was submitted was explicit that Mr. Brundage and Mr. Bailey should remain liable in conformance with the verdict. And it was not it was not negligence to fail to do so in the first Rule 60A motion because we actually did do so. We did asked for a joint and several liability against Brundage and Bailey on the reply brief. And as Justice Gish noted, it was without negative consequence to Protostorm that we did it on reply, because nevertheless, the district court addressed joint and several liability in substance, on the merits, and fully.
Thank you. And you'll have time on rebuttal.
Thank you.
Okay, Mr. Pontiero.
Good afternoon, Your Honors. May it please the court. My name is John Ponterio. I'm here on behalf of Protostorm Inc. Thank you very
So
much.
why isn't all of the responsibility for this Mount Cotton's? And after all, the letters that go in post-judgment are by Mr. Goodman on behalf of Mount Cotton. Why isn't this all their business and Foley is not responsible?
Well, Your Honor, Mount Cotton and Foley were co-counsel on this case from the very beginning. In fact, it was actually Jonathan Moskin, when he was at White & Case, that was hired to commence this lawsuit. And although Foley, and then when Jonathan Moskin changed firms and went over to Foley, he took the case with him at that time. But nowhere in the record did, and of course the defendants did not submit any evidence to show the limitation of Foley in this representation. They were jointly doing the case from the beginning all the way through the end of the trial, even on the appeal. And while the letters after the trial were submitted on Mount Cotton letterhead, they were, the drafts were submitted to Mr. Moskin to review and comment on before they were submitted. And they were submitted as a joint letter. So even though they're separate attorneys, it's got to be on somebody's letterhead. And it happened to be on Mount Cotton's. But there is evidence in the record that Mr. Moskin reviewed and approved each letter that was submitted to the court. So the idea that Mr. Moskin can now say, well, you know, I was at the trial and I participated, but anything bad said was on Mr. Goodman, not on me, is quite frankly, it's just not believable. They had a duty, even if Mr. Goodman said something incorrect, I think that they had at the very least the duty to come forward and tell Mr. Goodman, hey, you did something wrong, or go to the court and say, Judge, I'm sorry, but we have to correct the record. And
so I want to turn your attention to Mr. Veroniotis's letter of October 15th to Judge Chen. And I really hope that Mr. Adler will address it. As I read that letter, it seems to be saying, it seems to have the defendant there agreeing. Mr. Veroniotis seems to say, well, yes, there is joint and several liability between all the parties. I refer to you know, that paragraph on page 258. Similarly, the co-defendant's insistence that all compensatory damages must be assessed only against ATSK also is not what the court ruled on the apportionment application. He seems to concede that the liability among Brundage, Bailey, and ATSK is joint and several. Am I misreading that letter?
No, I believe you're reading that correctly, that at that moment, ATSK, and that's the first time ATSK was actually advocating that position. And that is also the letter, the reason it was in there is that it's also the letter where I believe the defendants finally woke up and realized their mistake, because it was after that letter that they put in a reply to the trial court to say that now they wanted the judgment entered against ATSK, Brundage, and Bailey joint and severally. Whereas
I mean, the surprise in it is that the federal court didn't seem to accept this, even though it seems to me that both sides agreed on it, and the problem for the defendants here, I think, is that they're stuck with what the Second Circuit did. I mean, I don't think the appellate division is in a position to say, well, why did you do that? The Second Circuit, to the Second Circuit.
The Second Circuit definitely found the waiver, and that waiver occurred at the trial at 2 points. The Second Circuit appointed at 2 points. One was at the charging conference, and the other one was immediately after the verdict, when they requested the reallocation of the percentages to Brundage and Bailey to ATSK. And in fact, it's those pages are cited repeatedly, not only by the trial court and the Second Circuit, but even in the letter, the first letter that the defendants wrote on behalf of Protostorm referred to their own comments at that charging conference about allocating the percentages to ATSK. I don't have a theory, but maybe it was somehow confusing Respondent Superior with joint and several liability, because really after the verdict came out and ATSK was found, the firm was found 75% liable, as well as two of the individual attorneys, there was no need to worry about Respondent Superior. They already had them as a defendant. The jury found the percent of negligence to them. So all they needed to ask was for a judgment against the firm, Brundage and Bailey, jointly and severally, for the amount of the damages.
Thank you so much.
Thank you, Your Honor.
Okay, Mr. Adler, I'll give you 2 minutes.
Thank you, Your Honor. So I'd like to first address.
Mr. Adler, I just point out, I understand what must be your frustration. It seems to be something which everyone agreed to, that it should be joint and several, but yet it comes back to the point that my colleague Justice Gish made. At the end of the day, the Second Circuit said you waived it.
The second, so I'm going to address that. So first of all, with respect to the Second Circuit, since this is not an appeal on comparative negligence and who did what, let's just take the waiver on its face. So let's say that it really was Foley that made these comments that in fact were uniformly made by its co-counsel. Why isn't it a waiver that in the opening letter brief on the Rule 60A motion, there's a request for a joint and several liability of the Antonelli firm, but not a request for joint and several liability of Mr. Brundage and Mr. Bailey. So I think we start with the legal point. And the legal point is that waiver is not conferred by silence or mere inaction. We cited the Rizzoli decision of this court, and there's many other decisions going all the way back to Justice Cardozo on this point. Waiver is an intentional relinquishment of a known right in clear and unambiguous terms. So the proposition that there was a waiver, whoever the lawyers were, that there was a waiver because the lawyers talked about joint and several liability for the Antonelli firm and not for joint and several liability for Bailey and Brundage, it's a waiver of that as against Bailey and Brundage, it runs afoul of that law, particularly where, as a matter of logic, let me
stop you because this is where I'm having trouble with it. I don't dispute what you say about what constitutes waiver, but the problem I think that you have is whether the Second Circuit was correct or not in finding waiver. They did, and that provides a very difficult situation for us. And I know the trial court talked about waiver in not making the request in the first Rule 60 motion, but actually the Second Circuit is referring to waiver that was made at trial. I just don't know how we get behind that, at least for pleading purposes, to start separating you out from the other defendant here. I don't understand it, I'll be honest.
I think, Your Honor, you don't have to get behind it. I think you look at the materials properly in the record, which show that first, the parties agreed that joint and several liability could be addressed after the verdict, as the federal court noted. Second, it is the law that joint and several liability can and should be addressed after the verdict, as the federal court also noted. The federal court noted that it was borderline frivolous, that was its term, for the Antonelli firm to assert that counsel for Protostorm had waived liability through their statements at the trial. And even Supreme Court, in denying our motion to dismiss, found that Foley in particular did not act unreasonably in respect of the joint and several
Right, so
liability
from
issues
your
at
point of
trial.
view, the only one who got it wrong was the Second Circuit.
Your Honor, I think that insofar as the Second Circuit made a finding of waiver, it is perfectly clear what they are talking about. And what they are talking about is not the allegations in this case. The allegations in this case are, after trial, Foley wrote letters that were too late in seeking joint and several liability. That's not what the Second Circuit is talking about. The Second Circuit is talking about conduct at the trial. It's a different point of view, even putting aside which lawyers are which.
Okay, thank you so much.
Thank you, Your Honor.
All right. American Transit, I believe, was submitted. So People v. Floyd Thorne. Mr. Zapata, you have 6 minutes.
Thank you, Your Honor. Ronald Zapata with legal aid for Appellant Floyd Thorne. The police officers here did not have reasonable suspicion to forcibly stop Appellant when the only description given by the complainant that Appellant matched was that he was a black man. The description of the perpetrator provided to the officers was that the perpetrator was a black man, 5 feet 8 inches tall, wearing a baseball hat, heading west from 81st Street and 3rd Avenue, and according to the officers, wearing all dark clothing. But Appellant was 6 foot 1 inches tall, and therefore considered a tall height rather than the average height of 5 foot 8. He was not wearing any headwear, and he was walking north and not anywhere west of 81st Street and 3rd Avenue. And he was also not wearing all dark clothing, but instead was wearing a light gray t-shirt during the mid-July evening in Manhattan. Therefore, the only part of the perpetrator's description that matched Appellant was that he was a black man, and that is insufficient to provide reasonable suspicion to forcibly stop him. Significantly, Appellant had several distinct characteristics that were not part of the description, thereby indicating that he also was not the described perpetrator. He had a bushy goatee that was so distinctive that the officers asked the complainant if the perpetrator had a goatee, and she said she did not know. He also had large prominent tattoos on his forearms that were not part of the description, and he was carrying a backpack that was not part of the description. Now, the officers' other justifications for forcibly stopping Appellant were based on hunches and speculation, which this court and the Court of Appeals have held are insufficient to provide reasonable suspicion for a forceful stop. First, they mentioned that they had a hunch that the perpetrator might have changed clothes, and therefore they could have ignored the description of the clothing description provided for the perpetrator. But this court, such as in People v. Thompson, has found that such speculation cannot provide reasonable suspicion for a forceful stop. And indeed, any finding otherwise would make any clothing description for a perpetrator completely irrelevant in the DeBoer analysis. And courts, however, have consistently considered clothing as a major identifying factor in a DeBoer analysis.
Mr. Zapata, the people argued that it was the defendant's reaction to the police officer's statement, "Stop, can we talk to you?" That caused this situation to evolve the way that it did. What say you with respect to that argument?
In terms of, like, at that point, they still did not have reasonable suspicion to forcibly stop him. Even if they had at most a level 2 common law right to inquire, he had the right to ask, "Hey, what's going on? Why are you doing this?" And they did not have the right to grab his arm and then try to push him against the wall and instead force him to the ground. At
the point in time that they asked him, what was there outside of the statement, "Can we talk to you?" Was there any further inquiry before he was told to put his hands up on the wall?
No, Your Honor. All they said is, "Can we talk to you?" He said, what is this all about?" He was,
"Why are you stopping me?"
Yes, and then they grabbed his arm, tried to push him against the wall. Oh, well, they also told him, "Put your hands up against the wall." So
Right.
that by itself.
At what point does the officer? At what point does the officer say that he saw what he thought was the outline of a gun in his bag?
It was after the stop. So after he was already forced to the ground,
And-
the officer first said that he could see through the bag and saw a reflection of a gun through the bag. And then he said he saw the outline and felt the outline. Afterwards, he felt that. But that would be irrelevant to my argument, which is they had no.
The officers also say that they're trailing him. I'm not sure that's the right word, but it's that idea as he's walking and they're in the car and he's looking away from them. Where does that fit into this picture for you?
Well, Your Honor, those they try to equivocate that to some sort of flight, which is just not correct. In terms of looking into store windows, the Court of Appeals has stated that actions such as looking into houses and store windows is not sufficient for finding a reasonable suspicion. Look at People v. Johnson, the People v. Towns, and significantly, the Court of Appeals has stated that reasonable suspicion may not rest on equivocal.
Mr. Zapata, this spotting of the defendant by the police officers takes place 5 minutes after.
8 minutes.
But I think the timing of it, when you go from the timing that's on the transmission, it's actually 5 or 6 minutes. I know the claim is made that it's 8 minutes, but I think it's actually 5 minutes after the call is made that the first spotting of the defendant takes place. And spatially, it's close to the area where the attempted gunpoint robbery is reported.
Well, so a lot of this is relying on speculation. They don't know if he
Well, the
went
8
into the
minutes
building,
is
if
not
he went into
speculation.
I'm sorry?
The 8 minutes is not speculation. I think it's really 5 or maybe 6, but let's say it's 8.
Okay, well, I mean in terms of okay, now they see the first black man they see when they turn 3 blocks from the incident.
This is 1:45 a.m. at 81st and 3rd. Is that it?
Yes, Your Honor. And so they only heard the transmission about the complainant's description after they went there. They made a right, and driving merely 3 blocks and seeing the first black man they saw that didn't match any of the other descriptions did not provide reasonable suspicion here, especially since you did then need to speculate, okay, was the perpetrator walking? Did he have a vehicle? Did he maybe go into any other building? Any other finding is based on it was all speculation to believe that he had to be walking, and therefore that did not provide reasonable suspicion to stop him.
Okay, you'll have more time on rebuttal, and I neglected to mention when argument started that Judge Gish is recused on this case, gentlemen, so the applicable rules with regard to that apply. All right, Mr. Yarnell, you are up and you have 5 minutes. 6 minutes. Apologies.
Thank you, Your Honor. Brent Yarnell for the people. May it please the court. The officers here had reasonable suspicion. I'd like to review all.
What kind of a description did they have from the radio run? What was contained in that, so they could identify the defendant on the street?
The description was that the defendant had accosted a victim at gunpoint on 81st Street between 2nd and 3rd Avenues. The description was that the victim estimated that the suspect was about 5'8", based on the fact that she was 5'6", and she could definitely tell that the suspect was taller than she was, but she wasn't exactly sure how tall. She said approximately 5'8". In addition to that, she described the suspect as fleeing west on 81st toward 3rd Avenue, and then she later told Officer Cito that when he reached 3rd Avenue, he turned north on 3rd Avenue, and then addition, she said that the suspect was wearing dark clothing. So when
she wasn't sure about the clothing, was she?
She said he was wearing when she initially spoke with the dispatcher. The dispatcher asked her, can you say what he was wearing? She said, I'm not sure. And then later, when she was in the car with Officer Cito, he gave her further inquiries. We don't know exactly what his questions were, but that she told him that that she did recall that the clothes were wearing dark clothing. And, I think that's pretty natural. I think it's understandable that you might ask somebody, what was he wearing? And you might say, I don't know. And then you might say, well, can you say anything about it? And you might say, I do know it was dark clothing. That I can tell you.
It's natural that you wouldn't notice what do they call it, a Van Gogh?
A goatee?
A goatee?
Well, we know the reason she didn't notice the goatee was because the defendant was wearing a ski mask at the time he accosted her. Of course, officers
stop. Nowhere in this radio run does it say that the perpetrator was wearing a ski mask. So I don't know where you pull that out from, but nowhere, not even the people on the hearing argued that. Where are you getting that?
Well,
the fact that there's a ski mask in the bag after he is caught does not mean he had one on, and the complainant did not say that.
It's true. The ski mask was found in the bag. It was not described in the radio run. And it's true that officers Metaxas and Delgado didn't hear anything about it over the radio. All I would say is they're not required
and none of the officers testified to that either, counsel, at the hearing.
No, they
not
testified
one
that
of
the
them.
ski mask
I read
was
the
found in the
entire
bag.
transcript.
Well, I disagree about that. I think that Officer Delgado
Tell me what
testified.
page, what officer says that that one of the perps is wearing a ski mask.
Well, I don't believe that Officer Delgado testified.
No one testified to that.
Delgado
This is July. Mr. Yarnell, this is July.
Yes,
I'm sorry,
July
I don't understand the question.
I asked you whether this is taking place in July.
Yeah, it was taking place in July. And my recollection is that Officer Delgado did testify that the bag contained a ski mask. They didn't know about the ski mask when they saw.
After they went through the bag, right?
Sure, but the only point that I want to make here is that the officers saw that he had a ski mask when they saw that he had a goatee when they saw him on the street. They weren't required to assume that the victim would have seen the goatee or would have remembered it when this event happened late at night. It was a very, very fast interaction. They didn't know if something was on his face or not. So just because she didn't see a goatee doesn't mean that the goatee means that the individual they saw on the street was not the suspect. And I think it's so crucial to keep in mind here, so crucial that this occurred at 1:54 a.m.
Without the goatee, isn't this sort of a very bare bones description? 5'8", black person, black male with dark clothing. I mean, everybody, I look out my window, there's nobody in New York City that doesn't wear dark clothing. I can testify to that. Everybody wears a black coat in this city. So
well, the crucial point here, it's true that it wasn't a detailed description, but the crucial point is that this happened at 1:54 a.m. when nobody else was on the street.
Why don't we focus on what is the crucial point? Tell me explain to me how you believe that under our precedent that the general description you have permitted the police to go from stop, I want to ask you a question, to a forcible level 3 stop. Seems like they skipped a couple of levels in their process.
Under people
Explain to me how a general description of black man wearing dark clothes and a baseball hat, which doesn't completely match this defendant, provided the police with sufficient reasonable suspicion to warrant a level 3 stop, which is what the people argued at the hearing, that they were entitled, that the police on these facts were entitled to engage in a level 3 stop from the inception.
Under People v. Conley,
Under People
this
v.
court
what?
found.
Which case? I'm sorry,
Conley.
I didn't hear.
Conley,
Okay.
which is cited in our brief, this court found that where the suspects were described as a large group of Asian men, that was the only description that was provided, and they were found a few blocks away, like here it was 3 blocks, and they were found a few minutes later, and like here, they were found at a time when nobody was else on the street. This court
That's not
said,
the testimony, but go ahead.
the testimony
the
was
testimony.
that there were only 3 to 4 pedestrians on the street at that hour. That's what Delgado said. So I would submit that that is
That's nobody?
indistinguishable.
3 to
And
4
this-
people on the street is nobody?
It's barely anybody. It's a very small number of people. And this court said that when you find somebody in such close geographical and temporal proximity at a time when there's very few people on the street, that creates, quote, a strong inference that the suspects were connected to the crime. In addition to that strong inference.
Counsel, Judge Mendez is asking you a question.
He's not coming through.
We can't hear you, Judge Mendez.
Okay.
It's all broken up.
It's broken up. Sorry. Still, it sounds garbled. I'm so sorry. If you want, email me the question and I'll ask it for you.
Okay.
Counsel, can I ask you to focus on, in People v. Moore, the Court of Appeals found that the police did not possess sufficient reasonable suspicion. And in that case, the defendant, the radio call involved a black male with a gun, approximately 18 years old, wearing a gray jacket and a red hat. Quite distinctive combination of clothing. And there the court found that that was not enough. So there are a lot of cases that would say that the description here certainly was not enough to warrant a level 3 stop at the inception of the interaction, because there was not even an attempt to get information here.
Well, I would direct Your Honor's attention to this court's decision in People v. Andrews, where the suspect was described as wearing black pants and a black top and glasses. He was described as fleeing east from 118th Street and Lexington. He was found moving east on 117th Street towards 2nd Avenue. And I would say that that is comparable to the facts here, where defendant did partially match a description of the suspect as wearing dark clothing. He was described as moving west. He was observed moving west across 3rd Avenue, west towards Lexington Avenue, and he did match an approximate height that was given by the victim. And I really, I've said this before, but I do think, even though, yes, Officer Delgado said 3 to 4 people on the street, that's still not a lot of people on the street. The fact that he was found so close, that this was a fast-moving situation.
Are you saying, Counsel, are you saying that an officer has the right to engage in a level 3 stop if there's only one person on a street that matches a very general description? That's what you're saying?
No, that's not what we're saying, because the
okay,
officers had
so
more
if
than
you're
that.
not saying that, then you're saying that the police still would have to engage in some kind of inquiry in order to ensure that the person they are seeking is this person. No?
No, I'm saying they had more than a general description. He did partially match a general physical description. He did match the described direction of flight. And I would also say that the furtive movements he gave in were very unusual. He was walking straight ahead quickly with his head turned all the way to the left. That is a highly
furtive
unusual
movements is when somebody is trying to avoid having their hands, we talk about that. You're saying that he was acting suspicious. That's still a hunch.
Yes.
This is nothing but a hunch. And the fact that
Judge
they
Manzanet, I think Judge Mendez has emailed a question to you.
Okay, I didn't see it before, but let me check. Thank you, Judge Friedman. All right. In Con Lee, what rose it to a level 3 stop was that the person had blood in his clothes and scratch on his nose, which was consistent with complainant that there had been a fight with a group of men of Asian race, not that there was simply few people on the street and that it was close to where the incident took place.
That's true, but before they saw the blood and the scratch, the court said the fact that they were found in such close proximity at such a late hour did establish a strong inference that they were connected to the crime. What I'm saying here is we also have that strong inference. And then in addition to that, we have the very strange movements he made. We have the description of the height, we have the clothes, we have the direction of flight.
And wasn't the height about 5 inches off? That's almost half a foot. So it's not that close. There's a big difference between 5'8" and 6'1". Big difference. I have brothers who are 5'8" and know men who are 6'1", and they're much taller.
I think heights are hard to estimate, especially in a fast-moving,
Except here, the complainant said the complainant gave us a point of reference. She used herself as a basis for measuring her perpetrator. And she said, well, I'm 5'6", so I'd approximate he's about 5'8", which tells me she didn't see him as being much larger than her.
Well, she didn't say he didn't seem much larger than her.
She said, I'm 5'6", and he's 5'8". That says it all.
The officers knew that he was certainly taller than complainant, and that did increase the possibility that he was, in fact, the suspect, especially given the fact that heights are difficult. You know, I don't agree that somebody looks at somebody and can tell the difference between an average person is technically a 5'8" and a 6'1" is technically a tall person. I don't know that the victim knew that and knew that terminology. I think she was doing her best after a very quick, very stressful encounter to make an estimation. And at a time when there was nobody else on the street, this guy was very close by. He was a few inches off from that. He wasn't exactly it, but he was a few inches off. And by the way, I'd just like to note, I know I'm over time, but a large part of defendant's argument is attacking the officer's credibility. Both Officer Metaxas and Delgado said it wasn't an exact match. It was close. He didn't exactly match. And they both explained at the hearing why they thought that they still had reasonable suspicion, even though it wasn't an exact match. And I would just submit to you that their testimony at that hearing absolutely spoke for their credibility. It spoke for their credibility strongly. We ask that you affirm. Thank you.
Thank you. Mr. Zapata, you have 2 minutes.
Thank you, Your Honor. I just want to address a couple of the, I guess, false statements that the prosecutor made here. There is absolutely no evidence that the officers were told that the appellant, the perpetrator, was walking north. It was never told on a radio run, was never mentioned in the facts at all, and they had no...
It doesn't say something about towards 3rd Avenue.
Yes, they said westbound, and that is not west. He wasn't even on the west side of 3rd Avenue. He crossed the street in front of the marked police car going west. So he was never even on the west side of the street when he was on it. He was not wearing a ski mask. There was absolutely no testimony of him wearing a ski mask. It seems like the prosecutor is essentially stating
they didn't say he was wearing a ski mask. Prosecutor didn't say he was wearing a ski mask.
Yes, well, from my
argument,
he made
a reference to there being a ski mask, but he really didn't say it.
Yes, I guess he was trying to infer that because that the complainant would have mentioned the goatee because he was wearing a ski mask, but then that obviously would have been part of the description if the complainant
well, it certainly would have stood out on July 18th.
Yes, exactly. Yes, as Justice Mendez had mentioned, in terms of people v. Conley, those factors were to be able to ask questions of the defendant there was only allowed for a level 2 stop, and the level 3 stop was only allowed only once they saw the blood after to connect him with the assault. And the one other thing I wanted to address was in terms of the prosecutor's arguments. They didn't mention it here, but they mentioned it in their brief about how the police, even if they don't have reasonable suspicion, can somehow add to reasonable suspicion because the crime alleged to involve a gun. There's absolutely no public safety exception for a reasonable suspicion requirement. And so if there's no reasonable suspicion to identify the suspect as a perpetrator, you can't say, okay, but the offense involved a gun, therefore, even though I don't have reasonable suspicion to suspect this person as being the perpetrator, that because it involves a gun, you can stop him. That is not the law. And therefore, I ask this court to reverse the conviction.
Thank you so much.
Thank you.
People versus Joel Sanders.
May it please the court, my name is Chris Operson from DLA Piper for Mr. Saunders. Appreciate the court's time today. I know we're last, but we will, one of the things I can tell you is there's been a lot of ink spilled on this case, many, many pages of briefing. Not my intent to go back through and re-argue everything in the extensive briefing. I know the panel has done so, but what I would like to do today is try to ensure that we haven't lost the forest for the trees here. One of the things we can do is when you have 14.
Well, let me see if I can help focus you on what argument is certainly of concern to me. I want to talk about the collateral estoppel arguments that you make in your brief. And in particular, let's start from a common ground here, which is that under the law, it's the defendant who has the burden of showing that the prior jury verdict necessarily, and I'm going to put that word in quotes, decided a particular factual issue raised in the prosecution. And I want you to focus in for me, particularly on the first case in which there were acquittals for falsifying business records. Okay, that's where I want to go. And those were the jury in the first case, they granted acquittals on those, right?
Justice Gish, yes, ma'am. That's absolutely right. There were acquittals on 14 falsifying business records counts.
And the others were dismissed, so we're not really concerned with them.
Correct.
Now, those acquittals, the evidence of the transactions underlying that form the basis for the conspiracy charge in the second trial?
Your Honor, yes, ma'am. They both for the conspiracy charge and the object of the conspiracy, as well as the scheme to defraud, which was count one in the indictment.
The scheme to defraud was based on those as well?
It was, yes, ma'am.
Okay. All right. So tell me how you satisfy the necessarily decided aspect of collateral estoppel with respect to that, or not? Yeah.
Your Honor, both as to the scheme to defraud and the conspiracy count, we believe that the 14 false business record counts that were resulted in acquittals do under Acevedo satisfy both the evidentiary and the ultimate facts test for collateral estoppel. And I will just note that there were three categories of the false business records counts that apply to different factual underpinnings that were then used by the prosecution in trial two. And if I could just, and these were pointed out in the briefs, but I'll just recite them for the record here. Counts 21, 34, 49, and 69 related to what the prosecution at trial one referred to as the, quote, Joel's Amex, the fraud and the object of the conspiracy to try to commit fraud with respect to certain charges and transactions for an American Express that was, by the way, never proven or established in trial one that it was ever used by Mr. Saunders. It was just termed Joel Saunders to create a perception in trial one that was an Amex that the charges on which he was responsible for incurring for the firm. There's also a second category of counts 51, 52, 53, and 57, alleging that Mr. Saunders falsified or directed the falsification of business records to meet an asset coverage ratio covenant. So those are the asset coverage ratio false business record counts.
Right. Okay.
And then the third one, and that's all again part of the object that is part of the conspiracy, as well as the scheme to defraud.
Did the acquittals necessarily decide a factual issue regarding those falsification of business records that was also part of the scheme to defraud and the conspiracy?
Your Honor,
the trial judge said, gee, we can't really tell why they decided or why they acquitted in the first jury trial. It could have been other reasons other than that that he didn't do it, or that he didn't do, wasn't part of I guess it was a master plan was the issue they were talking about. Like, for instance, the court said, gee, they could have found that he didn't make the actual entries and that he didn't satisfy the acting in concert. Wouldn't that be ambiguous or ambiguous enough that they could rely on the facts underlying the false business records? And I know it's a complex question, it's a complex case. Couldn't the prosecution do that?
well, that's what they did here, Your Honor. But our position is that's always the rub, isn't it, Your Honor? It's whether or not you can track back to or path back a certain way from the acquittals in a trial one when there's a retrial in trial two, and you have to look at other facts and circumstances, because you're not going to get an itemized verdict that says we found, we acquitted on this basis, but only because we didn't find intent, or we didn't find that he had a knowledge or the mens rea element.
And actually, that's to distinguish from the retried counts that were based on grand larceny, where the trial judge did make such a finding for the acquittals, saying that, gee, they didn't find intent. So we know the basis for the acquittals, right? It's a distinction.
Your Honor, as to 2 through 16, excuse me, those were the grand larceny counts that Justice Stoltz dismissed afterwards, where he did say that no reasonable jury could find that defendant Saunders or any defendant acted with the requisite criminal intent. But under O'Toole, I will just point out, which is one of the cases we cited in our briefs, it has held that if it's an acquittal as to an element, it's an acquittal as to the entire charge. And so therefore, when they try to use it in trial two as a factual underpinning for another count, and they didn't change the counts, they didn't bring new counts, they had the same scheme to defraud, and they had the same conspiracy counts that were still predicated on the same acts that were from the original indictment, with counts that had been dismissed or through acquittals. And so my point being is that in that case, yes, he did say that it was because no reasonable no reasonable jury could find that anybody acted with requisite intent. But Your Honor, that's an acquittal as to the entire count, all 15 counts of grand larceny. And under Acevedo, again, I want to go back to this point that when you try to use in New York, when you try to use a prior acquitted conduct as a factual underpinning for another cause of action or another count or charge, right? The New York doesn't see any difference and distinction between the harm to the defendant between evidentiary facts and ultimate facts. And Acevedo
it bases, Acevedo specifically said what we're looking for is necessarily decided. What was it necessary? Right? I mean, that's not whether it's factual evidence or an ultimate fact or an evidentiary fact. Isn't that what Acevedo ultimately comes down to? Was it necessary?
Well, I mean, in Acevedo's facts is an interesting fact pattern where they call the defendant, or they call the claimant from the first trial where there was an acquittal to the second trial to testify to try to establish some similar factual pattern with respect to the car on the wrong side of the road with the same license plate and the individual, and that was deemed to be improper. And the fact is that it was established in the first trial that he couldn't establish that was in fact the
That he
defendant.
wasn't there, right?
That he wasn't there. And Your Honor, what I'm saying here in the second trial here, when the prosecution attempted to bring the 15 grand larceny counts back in as factual underpinnings in their scheme to defraud and conspiracy, and they attempted to bring the false business records counts in again, the way that they presented those was the same exact way that they attempted to prove those scheme to defraud and conspiracy counts, as well as the underlying grand larceny counts and falsifying business records, and trial 1. So trial 2 was really just an overlay.
Yeah, but I get that, but I'm not really picking up the necessary aspect. When you look at the acquittals in the first jury verdict, which is where you have to look, what were the necessary factual do we know we don't know what the factual findings are. That's the nature of an acquittal. But was it necessary to get to an acquittal that they make a certain factual disposition that would be otherwise the same as what they needed in jury verdict or jury trial 2? In other words, how do you address the lower court's reasoning that the acquittals could have been based on something else, like the lack of an accomplice, or the fact that in the first case, the standard for the master plan was really acting in concert, and that's something different. They don't have to prove acting in concert for the conspiracy. Doesn't mean that they found that the entries weren't false. Or that he didn't even, yeah.
Yes, Your Honor. All I will say is that again, this is an attempt to try to unpack, a little bit of a murky pattern here, and that's always the case here. But what you can look at is whether or not the factual evidence that came in at trial 1 that was again used in trial 2 satisfied the elements or would have established any of the elements that, for example, Joe Saunders had any knowledge or dealt with Casino, Mulliken, or Canellis on some of these transactions, and there was no evidence that he knew about what was going on, for example, with the charges on the Joel's Amex, and there was really no evidence when you look and you unpack the testimony of Casino, Mulliken, and the other witnesses, Harrington, whether Joel Saunders had any knowledge or had any involvement in any of those changing the write-offs or working and reworking the asset coverage ratio action. So that Your Honor, what we're saying there is that because you have to sort of back yourself into this position and conclude that because there was no factual evidence to support that one of the reasons why there was an acquittal on those is that they didn't have any evidence that Joel Saunders was there, at the time and knew about what was happening with the underlying conduct. And the same would apply.
Counsel, you'll have time on rebuttal. We are now 4 minutes over your time. Okay? You'll have time on rebuttal.
Thank you, ma'am.
All right. Counsel, the floor is yours, Mr. Cohen.
Hey, thank you, Your Honor. May it please the court, David Cohn for the people. So,
I'm sure you want to address. I'm sure you want to address the issues that Judge Gish brought up, but I have a quick question for you. What count of the indictment was the email about the defendant not wanting to cook the books anymore? Did that relate to?
So, Your Honor, that was background evidence that goes to the his larger knowledge of the scheme to defraud. The cook the books email was written the day after an email exchange that the defendant had with Mr. Alter regarding the One London Wall recharacterization.
That he didn't want to continue doing what had been done with the consultation, capitalization and amortization of the software. Wasn't that an unduly prejudicial email to have elicited among the many that you had for the background of the fraud?
Well, Your Honor, actually, I read the email, and the trial judge read the email, and the prosecutors below read the email in a slightly different way. I think what they read, the cook the books, I don't want to cook the books anymore statement as meaning, was that I understand that we're doing all this recharacterization improperly with One London Wall. In 2008, this was the outset of the scheme. They didn't know that they were going to have to continue doing more and more and more of this in order to get the numbers they needed to continue getting their loans. So the defendant thought at that point, all right, we can do this. I'm sorry if there's a siren in my background. We can do the One London Wall recharacterization, and we don't need to cook the books anymore about this IT matter. I think that's what he was trying to say in that email. There's certainly a reasonable view of the evidence that that's what he was trying to say in that email. And this email just showed his consciousness of guilt of the larger scheme, which had actually begun about a month before. And he had just emailing about the One London Wall recharacterization the day before about cooking the books for that. And so when he's saying, I don't want to cook the books anymore with regards to IT, he's just saying, look, we're already doing something. I don't want to do any more right now. At that point in late 2008, right at the outset of the scheme. So this email, at least this is what the prosecutors alleged below, and this is what the trial judge allowed the prosecutors to proceed on the theory that this was just showing his consciousness of guilt of the others of the main scheme, which had already started. And the judge also charged to the jury that they weren't to consider that there were any other bad acts aside from those charged in the indictment. So that they weren't to consider that there might have been bad acts that predated the November, December 2008 recharacterizations that were the subject of the charges. So the judge cured any potential prejudice by giving that instruction to the jury that they were to focus on the conduct in the charges and not on any other perhaps uncharged criminal conduct that might have gone on. So to the extent that there was any problem with that email, that was one email among a wealth of evidence showing the defense involvement in the scheme. And he joked with Kanellis about clueless auditors. He even admitted in emails that he lied to the banks about using the loan money to pay the partners. Those are just a couple of examples. There are so many examples of defendants' explicit acknowledgments in emails that he was intimately involved in the scheme. I guess
this is Judge Gish, but then the question is, if you have so many examples that relate to the particular acts of conspiracy, the underlying falsifying of records, then why did you need to put the cook the books in, which didn't relate to any of the underlying transactions? I mean, why load it on?
Well, Your Honor, the prosecutor and the judge believed that the cook the books reference in that email was to the other fraud that was going on, the charged fraud that was going on. Of course, the defense had the right to argue to the jury that he didn't mean the other fraud when he said cook the books in that email. I think that was a question that was reasonably submitted to the jury. And in any event, even if this had been error by the judge to allow this email into evidence, it was harmless in light of the wealth of other evidence implicating the defendant in the crime.
Can I now turn to the question of collateral estoppel, particularly as it concerns the counts that are conspiracy and scheme to defraud, which your adversary contends they need an object, they need underlying criminal stuff going on. Why, particularly the falsification of business records, what else could the acquittals mean in the first jury verdict trial that wasn't necessary in the second one?
Well, Justice Gish, I think your question is the exact right question to ask, and I think the trial judge got this exactly right. So under Acevedo, under this court's principles, collateral estoppel applies very, very rarely in a criminal case, and only when there's no other reasonable interpretation of the verdict except that a particular factual matter was decided in the defendant's favor by the verdict in the first trial. Here, as the trial court noted below, there were any number of possible explanations for the acquittals on those 14 of the 35 falsifying business record counts that were submitted to the jury. And in fact, Your Honors discussed one of the primary reasons why the jury might have acquitted on those counts. I think a very sensible reason why they might have acquitted on those counts is because they believed that the defendant masterminded the larger scheme. That was absolutely clear from the emails, from the documentary evidence. And so he was guilty of scheme to defraud, conspiracy, which was just conspiring to commit a felony, and the Martin Act securities fraud for falsely inducing the investors to invest in the private placement, but that he wasn't necessarily personally responsible for every single falsification of a document because he delegated that to others. And in fact, with the Amex, that's a perfect example. The Amex falsification idea, I believe it was Canellis and Mulliken who came up with that because they thought that idea would be less obvious to auditors than some other ideas they had for fraud. So they thought, well, the defendant wants us to find $50 million in cash for our balance sheet. How are we going to do that? So here's one way we can do that by manipulating the write-offs on Joel's Amex. And so they put together that scheme. At the trial, there wasn't necessarily convincing evidence, and the jury found there wasn't enough evidence that it was that the defendant absolutely knew that this was being done. However, so therefore they acquitted him personally of the falsifying business record counts relating to the Amex. But that doesn't mean that the conduct didn't occur. And it doesn't mean that the records weren't falsified. It just meant that the jury had a reasonable doubt that the defendant had actually been personally involved in the falsification of those records, or that maybe the accomplice testimony wasn't sufficiently corroborated, as I believe that the Court of Appeals found in the case, in the Goodman case. So what the trial judge said was because there are any number of reasons that there could have been acquittal on those counts that were not indications that the conduct did not occur, then therefore it's fair game for the prosecutor to talk about, the prosecutors to introduce evidence of that conduct at the retrial. That's a completely proper application of Acevedo. Same thing is true with the grand larceny counts. The judge, Justice Gish, as Your Honor noted, the judge found that the people hadn't proved the grand larceny counts because there was no evidence of the specific larcenous intent, which is under the law the intent to permanently deprive the owner of property. The trial testimony seems fairly clear from the first and the second trials that although Sanders and his accomplices defrauded the banks, they falsified the financial statements, they defrauded investors, they knew they were obtaining money from the banks and the investors under false pretenses. That's fraud and fraudulent intent. They did not necessarily think that they'd be keeping that money forever. They thought, well, we're in an economic downturn, things will get better in a few years.
Yeah, they thought that this was a Band-Aid until they could make more money.
Right. And so that's the difference between scheme to defraud and grand larceny. When you take property from an owner by false pretenses, that's fraud. When you take property by an owner with the intent to permanently deprive the owner of that property, that's larceny, right? And that's the difference between a fraud charge and a larceny charge. And in fact, the legislative history of the scheme to defraud statute explains that the scheme to defraud charge is intended to fill in some gaps in the larceny statute. It's intended to cover situations exactly like this, where there is clearly untoward conduct, illegal conduct going on, where somebody is obtaining a loan by false pretenses. Like, let's say I'm trying to borrow money to buy a car. Let's say I say my income is $100,000 when it's actually $50,000. The bank might not want to lend me the money if they knew my true income. Now, I'm still planning to pay back the loan. So I haven't stolen the money under the larceny statutes, but I've defrauded the bank out of the loan. That's the exact same thing that happened here. And that's what Justice Holtz recognized when he said, even though there was an acquittal of the grand larceny charges, the same evidence can still be presented at the retrial in relationship to the fraud charges. I'll just note, too, that even if there had been any issue with, sorry, Justice Manzanet.
I just want you to wrap up because as I've done with your adversary, I've given you both 11 minutes and your 11 minutes are almost up. So please conclude your statements.
Well, thank you, Your Honors. And for all the reasons stated in our brief, we ask this court to affirm the conviction.
Thank you so much. Counsel, you've got 2 minutes, and I need 2 minutes.
Yes,
Go ahead.
thank you. And I'll say, going back to Justice Friedman's remarks and questions about the cook the books, that's just one of many issues. And we've raised 14 assignments of error. And our point is that, Your Honor, and to this panel, you have to find that every single one of them lacks merit. And we've raised issues of Rosario defects. We've raised, Giglio, we've raised Brady issues, we've raised the juror issue. And the reason with the juror...
But they say that just 100 notes and there's no basis there's no reason to not accept the prosecutor's word on that.
Well, as to and there is,
You know,
Your Honor,
between the first and second prosecution, they conducted these interviews, and maybe they did it with a recognition that if they're going to write something down, they're going to have to give it to you, so they better just remember it.
and that would include not only witnesses that testified at trial one who were testifying again, but new witnesses. And it just seemed a little bit, and that's one issue, Your Honor, with the Rosario.
Counsel, defense attorneys do that all the time. So.
And I'd like to point out one of the things with the juror misconduct issue is we raised it as one of our assignments of error. If I could, I'm interrupting myself and I apologize. The cook the books email is significant, and to minimize it is, I think, a little bit disingenuous here. It was raised as a theme by the prosecution more than 100 times throughout the trial, and it was clearly something they were trying to connect to that, and that was a highly prejudicial, among other evidence, highly prejudicial, irrelevant document that was brought in. But as to Juror Phillips' issues, the reason we raised that issue, not only because it is she had been admonished dozens of times throughout the course of the trial not to talk to anybody. It goes without saying, if you're not talking to anybody, you're certainly not going to talk to a judge right down the hallway who knows that you're on the jury. She raised it on the third day, the morning of the third day of deliberations. She sent a note. The reason that's significant, not only does she not listen to instructions, she can't be trusted to listen to instructions, certainly can't be rehabilitated, but there were just insufficient, no tactful or probing Buford inquiry was done at that point when it should have been. It was merely an attempt to rehabilitate this juror, but she's significant because when the prosecution says there's no evidence that this had any effect on the jury, she is every juror. She is any juror. Juror Phillips represents exactly what the mindset. We get visibility into what one juror thought and believed as a result of every single one of these errors stacked on top of each other. So Juror Phillips isn't just Juror Phillips. Juror Phillips is any juror on that jury who was thinking the same thing at the conclusion of the evidence, which was, wow, Sanders didn't take the stand. We don't have anybody to testify as to these alone emails, but we certainly have the government telling us that you can't trust the defense and you can't trust defense counsel. Wow, we have all this evidence of him causing the bankruptcy. Oh, but we're told it's not relevant, but it is relevant. Why would the prosecution bring it up if it wasn't relevant? We have evidence of cooking the books, of outside fraud. The judge even found at trial one, the cook the books email was not relevant, and he excluded it. He let it in at the second trial, and they made it a theme of their trial. Every single one of these issues stacked on top of each other cumulatively creates a hugely prejudicial and unfair trial, and that's where we talk about the structural errors and the cumulative errors.
Thank you so much. We have your briefs and the record. This concludes the arguments for the Appellate Division First Department. Good evening, one and all. Thank you.